Hi, welcome to the Law Simplified. I'm Shavin Bandad Nayaka. Today, let's break down and attempt a question on agreement or offer and acceptance.
On the 1st of May, Andy offered by email to sell his car to Betsy for £10,000. He also stated that he would send his wife to Betsy's house on the 8th of May to receive Betsy's reply. On the 6th, Betsy sent an email to Andy saying, "Would like to have the car. Can you offer a 6-month guarantee against mechanical breakdown?" On receiving the email the same day, Andy sold the car to Christopher and sent a messenger with a note to Betsy's house to tell her of this. Before this note arrived, Betsy changed her mind about the need for a guarantee and posted a letter to Andy accepting the latter's offer. This letter was lost in the post. Advise Andy.
Now that we have outlined succinctly the question at hand, you'd notice that most questions in relation to agreement or offer and acceptance are very timely. In other words, it's chronological. One thing that a student or an examiner expects from a student in relation to answering a question of this caliber is to correctly identify when communications have occurred between the parties, because it is these communications that will determine if a valid agreement is in place and whether from that point onwards a contract has been entered into. Now, much like many other areas of law, we need to very quickly break down the necessary components and the communications. And to do so, an easy alternative is to mentally highlight the important sections in relation to the question. Now, in relation to contract law, it's actually quite simple to go from one communication to the other because you're expected to look at the chronological order. And you'd note from various questions, specifically in relation to even this question, dates have been mentioned to assist you in this. So let's break down this question before we proceed. Firstly, on the 1st of May, Andy has offered by email to sell his car to Betsy for £10,000. Now, the question itself outlines that there is a valid offer in place. Andy has communicated this via a prescribed mode, which is email, to sell his car for a specified amount, as in £10,000. Now, later on, when you go further into this topic, or rather when you go further into contract law itself, you'll be studying sale of goods, and one of the major elements to make sure that a proper contract is in place for a sale of good is that there must be a price allocated for it. So here, it's notable that an offer has been clearly stated out at the very inception of the question. He also stated that his wife would visit Betsy on the 8th of May to receive Betsy's reply. This particular statement, or rather this particular element in the question, outlines two specific things. Firstly, the fact that there is a prescribed mode where Andy is expecting that particular acceptance. So he wants Betsy to provide whether she accepts it or not via his wife, who will be visiting on a particular date. The second aspect of it is the timeline that has been provided. So Andy expects this offer to be either accepted or rejected by Betsy on or before the 8th of May. In other words, he has created a termination point for the offer. This is one way that you can look at it. On the 6th of May, Betsy sent an email to Andy saying, "Would like to have the car. Can you offer a 6-month guarantee against mechanical breakdown?" Now, at this point, what you are able to see is before the 8th of May, Betsy has sent over an email with a particular statement. The first thing you might note is this communication has happened before this deadline, this 8th of May deadline, and before Andy's wife has visited Betsy. On top of that, while it might not be by the prescribed method as such, it has been by the same method that Andy has used to communicate the offer. Or rather, you can even look at it as being more expeditious than the method prescribed by Andy. Next, you need to have a consideration of the actual statement itself. It states, "Would like to have the car. can you offer a 6-month guarantee against mechanical breakdown? Now, following Storer and Gibson, what is noted by court is any offer must be unqualified if you are going to accept it. You can't qualify it in any method. So, on the one hand, you might look at this particular communication as qualifying that offer and requesting for something else. On the other hand, you might even consider it as a mere request of information. But we'll look at that when we go a bit further. On receiving the email the same day, Andy sold the car to Christopher and sent a messenger with a note to Betsy's house to tell her of this. Now, at this point, there appears to be a contract that has been formed between Andy and a third party. So, this is where the inception of the problem happens, whether, if at all, Andy is bound by whatever communications that he has had with Betsy, if it has amounted to any acceptance, so on and so forth. I would argue that at this point there is no acceptance at all, and the original offer either stands based on the fact that the statement mentioned by Betsy is a mere request for information. Conversely, if it be considered as a counter offer, in which case there is no offer in the first place either. Before this note arrived, however, Betsy changed her mind about the need for a guarantee and posted a letter to Andy accepting the latter's offer. So at this point, we see that Betsy has gone ahead and posted something. Again, not in the prescribed manner, nor in an expeditious manner either. So what was prescribed was the fact that Andy's wife would come for the particular acceptance or rejection versus anything expeditious, like, for example, the email she used. And finally, this letter was lost in the post. So it requires a discussion on the postal rule as well. Now, based on these facts, we are able to identify the issues that are subsisting in this particular question. Firstly, is there a valid, actionable agreement in place? Because if there is an agreement, that would mean that Andy is bound to sell or to transfer the title of the vehicle to Betsy. Secondly, what does Andy's note via the messenger signify? Now, at one point before the 8th of May, once Andy has sold the vehicle to Christopher, he sends out a note to Betsy specifying that basically the vehicle has now been sold. So whether this amounts to a rejection of the offer that purportedly Betsy made in relation to the guarantee, whether it's a change of mind or a revocation of the offer, if, for example, Andy's offer still stands. So this is a conversation that you need to have or discuss. And finally, has Betsy communicated her purported acceptance successfully? This is where the postal rule comes in. One of the major aspects, however, that you must understand is all of this is dependent upon the previous communications, the preceding communications. If certain things are offers, then the outcome is different. If those offers have been vitiated, again, the outcome differs. So much like many other questions that we would be attempting, one of the best ways to go about this is to track back to the spider graph that you might have developed in order to understand each topic in contract law properly. So let's have a look at the spider graph for agreement or offer and acceptance. The beauty of having a spider graph mental image with you is you are able to identify the path that you must take in relation to the discussion at hand. So firstly, the discussion will revolve around the fact whether there is a valid offer in place. So we must exclude every other component in order to do so. More often than not, a question in relation to agreement on contract law will be more likely about what an offer is not rather than whether the offer is valid in the first place. So we don't have to have a discussion on pretty much everything in relation to this question, but we might need to consider things such as a counter offer, a cross offer, or whether it was a mere request of information. Once that is done, you will have to also ascertain whether there was some sort of end to this particular offer. Now, it is clear that at one point, Andy has sold the vehicle to Christopher and then sends a messenger out to inform Betsy of this. This can easily be considered as either a change of mind or a revocation, as per Dickinson and Dodds. Following this, however, there has been some sort of acceptance that has taken place by virtue of a letter being sent by Betsy to Andy. So at this point, we need to consider acceptance as well. There is a prescribed mode which has been stipulated by Andy, and this acceptance has not occurred in that manner. On the one hand, Andy was expecting the acceptance to happen via his wife, who would visit Betsy on the 8th of May. Conversely, however, communications has been happening via email, and at one point even Betsy either requested for information or qualified the offer via the email as well. So that's one major component that you must specify. It is noted that whatever message or whatever the acceptance that Betsy sent across was lost in the mail. Now, as per Adams and Lindsell, the exception of the postal rule will apply here, insofar as Betsy has provided to a third party the letter and she has done everything in her power to make sure that the communication happens, but it has unfortunately not been so. Now, if you want to go a bit above and beyond, it would be good to discuss cases which are far more modern, because we have considered things such as email, which is a far much more expeditious method than the postal aspect, or even for that matter, visiting an individual to get acceptance. But this is completely up to you, and it's something that will enrich your answers in the long run. Now that we have identified the various elements, when you are formulating your answer in relation to an agreement question, I will note back to my previous point, which is make sure that you have your chronological facts in order. Always break it down so that you have a clear understanding and identification of what happened when and in relation to whom. If you are interested in questions of this caliber, as well as how to approach them and how to properly answer them, and perhaps receive feedback on the types of questions that you're writing as well, make sure you visit law.simplybook.me, and I'd be glad to arrange a private tutoring session with you. So as always, have fun, stay safe, and obey the law. Cheers.